Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And today we are joined by a phenomenal criminal lawyer here. And even so great that a previous guest really got to get her on and have you speak to your students and everyone listening. So thank you so much, Leora, for joining us and looking forward to talking criminal law, talking everything here with you today.
Thanks so much for having me. It's wonderful to be here.
Now, Leora, maybe you can just tell us a little bit about kind of, first of all, what got you into to practicing law and certainly getting into criminal law specifically.
So law in general probably is in my veins. Family that really love to argue with one another, debate one another, have loud conversations with each other over dinner. And I pursued a degree in politics. I thought that was sort of where I was going to be headed. And so law seemed like the natural evolution from politics, and started at Osgoode and really was enamored by Alan Young and became his research assistant very quickly at the start of first year criminal law. And I don't think did anything else. I did, however, summer at a Bay Street firm just to make sure that I wasn't missing anything on the corporate side of the law. And I quickly realized that it was not for me and that criminal law was where I needed to be. So um, I think I'm just a litigator in my bones, and like to be an advocate. I usually am always for the underdog in anything and everything. So this seemed like the natural place for me to be. So that's the reason why for criminal law.
Yeah, I think everyone who's had Alan Young certainly can remember all of the stories that he would tell. I remember, I think, a criminal procedure, and then opting really late to do an essay, I think, instead of the exam, and probably like shouldn't have sent that in, sullied my name there probably with Alan Young, with the quality not probably being as top notch as some of the people in the class there. But so from there, you said, look, Bay Street's not for me. I'm into criminal law. And kind of what was then just starting into criminal law, now switching over from Osgoode there, and then getting into practice. And what did you find when you first started out with everything that you learned and putting it into
Yeah.
practice?
So the learning curve is, I mean, I think everybody I'm sure who's been on your show will say the same thing. The learning curve is steep in criminal law, right? You're finding your feet, you're trying to gain respect from the bench and from crown attorneys. You started as a young lawyer, you're often mistreated. I remember those days, particularly as a young woman. And you sort of gain the ranks, so to speak. You gain respect as you do more cases, but you're also learning a lot about yourself, a lot about how you advocate, a lot about how you're addressing the court, thinking about things, strategizing. All of that comes with a level of maturity. And so I think I've been blessed with fabulous mentors. And I encourage young lawyers to always find a mentor, not just one, but several people that you can call on, bounce ideas off of. I've been very fortunate throughout my career that I've had those people. So it started with Alan Young, and it grew to, Paul Burstein, who I ended up articling for. I did started articling with Brian Greenspan, and then shortly left his office and moved to Paul Burstein's. I just wanted to be more immersed in the law and wanted to be on my feet more, and Paul Burstein gave me that way. So I think he really paved the way for me to understand how to be an advocate. And then I moved to Joe Newberger's office and became a partner there, and stayed there for 7 years and had two beautiful babies there, and then went out on my own after the birth of my second child. So this is a tough field. It's a tough field for everyone, I think, but in particular tough for women who want to have children and a family. And again, I've been blessed with not only fabulous mentors, but blessed with a fabulous support system, which makes, being a lawyer much easier, so that I can focus on things that need to be done in the office, while I know that people are also taking care of my family back at home. And not everyone is blessed with that. And I've been very, very blessed with that. So I'm fortunate.
Now, what's the difference there? I mean, I think switching though in 2006-ish or so, I think we can probably correct me on that if I'm wrong, but
No.
from working, essentially at a firm and then going out on your own? Like, is there something? I mean, a lot of the people I come on that have either started right into their own practice, there's a lot of things that you don't realize, beyond obviously just criminal law itself. Maybe you can kind of share sort of how that transition went from you, what you've learned from it, and what maybe you can pass along to young lawyers, young women lawyers that are starting in criminal law, especially, about what to kind of expect that you don't really learn about at Osgood and other law schools, I think. And maybe they're doing a better job, today than years past, where it was more on the
Yeah.
theoretical side.
Listen, I think at the end of the day, law school teaches you, in particular, hopefully, how to think, but it doesn't teach you how to lawyer, and it doesn't teach you how to be a business person, and it doesn't teach you how to deal with clients. In particular, in criminal law, you're not just dealing with the client in a courtroom; you're dealing with the client as a whole, right? You kind of act as a social worker in some sense. You're dealing with their families, you're dealing with them, you're dealing with an entire family. And so I think when I left Joe Newberger's office, I don't think I really understood that. I think I thought at the time, I'm going to open my own office. I'm going to have this freedom. I'm going to be liberated, and I'm going to be able to do whatever I want, take on whatever cases I want. It's not that way. It's much more difficult because you're having to handle parts of a practice that potentially you don't have to handle when you're working for someone and collecting a paycheck, right? You're not worrying about the business end of things. Can I get clients? How do I bill legal aid? How do I deal with families? And do all of that and be in the courtroom. So as you know, the days are long, right? You start early in the morning, the court day ends at 4:30, and then really our day begins. The business day begins at 4:30, because now you're having to return phone calls and meet with clients and do your research and get prepared for trial, while you're also going home and hopefully being a wife, a mother, and a partner, and so on and so forth. So this is a very, very difficult practice. It can totally be done. But I find that young lawyers don't ask for help. And I wasn't embarrassed or ashamed to ask for help. I think people need help. And I think there's lots of senior lawyers who are prepared to help. I certainly am. I'm certainly happy to help young lawyers get organized and to assist them as much as possible. So again, blessed and fortunate that I have been, but it is a very, very difficult practice. It's so rewarding in so many respects, but it's incredibly difficult.
And I do think that there's a lot of maybe younger lawyers who are maybe afraid
Mm-hmm.
to, or even you have like the listserv there. It's like, what if I post a question and like
Mm-hmm.
people are gonna like eat me alive there about like, you should know this. How are you representing clients? So kind of, is there a way that, especially now with the things have changed with the pandemic, is there a way to approach senior counsel and say, I mean, I know there's programs like the CLA has, as well as
Mm-hmm.
through the Law Society, but is there a way to kind of demystify sort of the senior criminal defense lawyer and get into their heads and pick their brains on a case? Or is it just asking and you'll get those answers, and just putting it out there?
I think it's asking. I really do. I mean, I wasn't embarrassed to call up counsel who were not close to me, in particular, and call and say, listen, I read this case of yours on Quick Law or online. Do you mind flipping me your factum? And I've never had a lawyer say no. So, I think you have to ask. I think the real issue is, are young lawyers willing to do that? Are they willing to put themselves out there and say, can I do this? Can I just cold call a lawyer and ask for help? And I think the short answer is yes. It's the type of field that I find we are willing to help, and other defense counsel are willing to help each other. Listen, we often get criticized for not being a close-knit community, but at the end of the day, when we need each other, there are people there to help one another. And I think that young lawyers should certainly feel comfortable to call anyone and everyone and say, I need some help. What do you think? As I said, the worst thing that can happen is they say no. Right.
Right. And then you go on to the next person.
You go on to the next person on your list. Yes.
Now, I mean, in that vein as well, I think there's also sometimes with young lawyers running maybe their first trial, sort of that apprehension about maybe cross-examining, and typically maybe cross-examining a police officer, right? And feeling kind of intimidated by raising grounds to suggest there could be some kind of impropriety on their parts, and obviously you have to be zealously advocating for your clients. You can't have those fears there, but maybe from someone who's done it really well. We're just talking about a recent case there for you as well. Maybe you can sort of shed light into how to approach that, and not have those nerves, and deal with that, and raise those lines of questions, and then charter applications and all of that to say, look, well, officers are no different than other. We're all human, right? I mean, there's good bad officers, there's bad officers, and you got to go out there and then raise the reasonable doubt there, or be successful on an application to get your client the justice that they deserve. So maybe you can talk a bit about that.
I mean, listen, the nerves are par for the course, right? I mean, I still think I get excited about cross-examining police officers, but at the end of the day, there's still nerves, right? I mean, Superior Court trials and jury trials, there's still nerves. That's just part of this field, and that's good. But cross-examining an officer and calling him out on either fabricating evidence or being untruthful, I think you ought to be sure and feel confident in that position before you take that position. I found early in my career that some judges were not impressed with the fact that I thought an officer was lying. Other judges, kept an open mind. So I think you might get one or the other when you're in court. You might get a judge who's saying, "Hold on a second, how dare you make these types of allegations?" And then, that's why I say make sure you know your case, and make sure you're not calling out an officer if you don't really have very good evidence before you do it. But when you do it, believe in it, feel confident about it, and go ahead and do it. And again, I think sometimes the reception will be a good one, and other times you might not get such a great reception. But as I say with any advocacy, there's a sense of maturity that comes along in this field. In the beginning, you don't necessarily feel as confident, but over time and as you progress as a lawyer, you become more mature and you refine your skills, and it gets better and it gets easier. So I don't know, calling out an officer, I think is a good thing when it needs to be done. But don't be too quick to do it unless you're certain, I guess is sort of my motto.
Yeah, and I suppose it's like, if you keep crying like the boy who cried wolf, and when there really is a case there, then maybe in the bench's eyes, well, you've raised this point like 15 times before and weren't really successful. Why are we to believe you now, right? So
Right.
you got to be good, be careful there. And again, when there is the situations, you raise it and go successfully on it.
So
Now,
Bryce just asked a question, so I want to answer it if I can. And I think he's saying, like, short of calling someone a liar, is there sort of a more subtle way to do it? Hopefully I'm capturing his question well enough, but I think that's the question, or the import of the question is there a subtle way to say an officer is a liar without actually calling him that? And the answer is yes. So in the last 3 days, I did a trial in front of Justice Dwyer in Newmarket, and it was really over the Cannabis Control Act and whether or not my client, who had been traveling in a motor vehicle, blew a stop sign, whether or not he was in the car with marijuana in it. And the officer's position was, oh, there was shake all over the car. And it's sort of a classic phrase for officers to use to gain entry and to search a motor vehicle, is to say, oh, I saw shake or remnants of marijuana all over the car. And my starting position was not true. There was no shake there. It wasn't seized. There was no video. There was no photograph, so on and so forth. And I never called him a liar. What I suggested to him was that couldn't possibly be true on account of his actions. Right. So, officer, you didn't do this and you didn't do that, and surely you would have done this if it was there. It was really just a roundabout way of saying you're making it up without actually expressly indicating it. And Justice Dwyer agreed with me and said, quite frankly, I don't believe there was shake in the car. And again, even His Honor didn't go so far as to say he fabricated his evidence, but he did in a diplomatic way. right? He said, this is what I find. I find as a fact that there was no shake there, which indirectly really meant that the officer wasn't truthful when he gave his evidence. But His Honor didn't go so far as to say that. So I think it can be done without actually calling him a liar. I think there are cases where you just have to. And there will be those where it's so obvious that he's lying, and you're passionate in your cross examination, and it may get to that point where you suggest that the officer is a liar. And quite frankly, sometimes you have to, because you don't want to be accused of violating the Brown and Dunn rule by not having cross examined him that way. So sometimes it's really called for, and other times it can be subtly addressed, and you'll have to decide when you do that. And it really just depends on the facts of the case.
You
So
mentioned,
hopefully,
you mentioned sort of the trials there that you've done, and certainly over the last year and a bit, they've been partially done. There's been a lot of changes, obviously, with things being remote, and again, I think it's kind of been a mixed bag from the different criminal defense lawyers I've had on here with respect to credibility of witnesses when being done remote. So just kind of maybe you can share what the experiences have been like for you, comparing the pre-COVID when you'd have everyone in the courtroom versus in some cases here now you're going to be doing it online over Zoom, and kind of what's worked really well with the changes and what's sort of been challenges. And as we get the number is higher and higher, I think we're going to see more return to in person. But I mean, a lot of the stuff that's done remotely, I think, like set date courts, will probably hopefully be here forever. But let's get your take on how it's been, and maybe can give us some comparisons of how it's been done differently.
I mean, listen, as I said to you at the start of this talk, that I thought our system is so archaic. Like, I compare it to a Rolodex. I mean, we're just pretty dated when it comes to progress or technological progress. And so I think this really was a kick in the behind for all of us, to become more efficient. And so, on account of COVID, we've been able to, deal with set dates and judicial pretrials and pretrials far more efficiently. I think gone are the days where young lawyers are having to travel from Newmarket to Barrie to Guelph and Milton and back, all in one day. I remember those days where, you're running through the parking lot, spilling your coffee as you're trying to get to this 5-minute set date. I mean, gone are those days, I hope. But the trials, in my opinion, I know there are lawyers that would disagree with me, that has to be done in a courtroom. There is an element of this profession that really calls out you being in person and seeing the whites of a witness's eyes and the complainant's eyes, rather than seeing it on screen. And I know there are lawyers who will disagree with me and say, yeah, but the judge can zero in on the person on the screen. And I disagree with that. There is a feeling of being in a courtroom that you don't get when you're on screen, where you can actually feel the witness, feel them being uncomfortable. And I don't think that it's not the same reception as a defense lawyer when you're on screen. Like, I can feel the interaction between myself and a witness when I'm in a courtroom, and I don't sense that when I'm on screen. I have no objections to doing certain things, motions, pretrial motions, no objections to that. But cross-examining witnesses, I want to do it in person. During COVID, I was able to do, 3 murder trials, judge alone, where the Crown got the Attorney General's consent, and we did judge alone trials on murder. And so efficient, so well done. It was smooth and easy. So I think that might be also a place for us to progress, where we don't necessarily always have to do jury trials when it comes to a murder trial, where Crowns will not feel like they can't ask for the Attorney General's consent to be able to do those trials in a judge alone capacity. So I think that also was a new development. So I think there's been some good changes, but I think there are other things that I haven't completely agreed with, where judges are far more comfortable on Zoom, or where Crown attorneys are more comfortable on Zoom, and I'm not. So anytime I'm asked to make a choice between an in-person and a Zoom, you'll find me in the courtroom. So I'm back in court now. If there's an opportunity for me to be in the courtroom, I'm running to the courtroom.
I see a question here from Roxana. It's
Mhm.
about, I guess, officers being in the courtroom observing. I'm presuming it's the the officer in charge after they may be called, and they just sit kind of as like the co-counsel, sort of sometimes as to the crown.
Yeah.
What are your sort of takes on that, or I mean,
So
of having people in the audience there, I suppose, or um,
so two things about officers, a part of the process. First things first, I never allow a police officer to be engaged in a judicial pretrial conference ever. It's like my number one rule. I know they show up to judicial pretrials and I always say out. Like I don't need them to be part of that process. So that's just been my rule from, I can't even remember how long. And I remember when I first started, people were sort of surprised, like Crown attorneys were surprised when I said, I don't want the officer in the judicial pretrial room. And judges were, yeah, I agree. They shouldn't be in the pretrial room. So don't be afraid to call them out when you don't want them a part of the judicial pretrial process. As far as the courtroom goes, I mean, it's a public courtroom, so you got to be careful. If they are a witness, you always want them to obviously testify before they take a seat beside Crown Counsel. But after their evidence has been provided, you will either take the position that you may need to call them in any type of a reply evidence. And so you say to the judge, listen, this witness is about to testify. I'm worried about what he or she may say. This officer took the statement. I may need to call the officer and reply. I'm going to ask that he or still be excluded. If the officer is not engaged in anything sort of closely related to any of the witnesses, then I'm afraid you're kind of stuck with them sitting in the courtroom. There's not much you can do about it. So it is what it is. Don't be distracted by them.
now, the other thing, I guess you probably get a lot of. I think all the criminal defense lawyers that I've had on often get asked the question, sort of the variation of, how do you sleep at night,
Yeah.
knowing that you are representing, I mean, I know even like a few weeks ago there was murder charges withdrawn. There you did, from one side of the bench, or sort of one side of the equation there, everyone's probably applauding you like amazing work, and then on the other side probably they're like, Leora again, how does she sleep there getting these people that get in the court of public opinion sometimes is different than the court of
Yeah.
law. And then how do you kind of reconcile when people sort of have that opinion, and what do you say in response to that?
Listen, I think every defense lawyer has a variation of how they're going to answer that question, right? I'm sure in all the defense counsel you've had on, they all have sort of a different way to answer that question. The answer to that question traditionally for me is I sleep really, really well at night. And but the case that I had just completed where the charges were withdrawn, I mean, unless people are really up to speed with what's going on with a case, it's very difficult for people to necessarily understand the procedures and the processes involved in criminal law, right? I mean, the media, the short clips, media attention that people are viewing and seeing are not what we're engaged in every day, where we can actually see the evidence, touch it, and review it. And so I think a lot of the times people are just misinformed, which is unfortunate, but it's, again, par for the course. So I say this to young lawyers, don't be distracted, right? Keep your eye on the ball. I mean, we're representing people, and we're not doing this because we're seeking particular attention from the outside world. We're really here to take care of the client. That is your number one focus. And that was my number one focus for the last 3 years for that gentleman. And I can tell you it was a victory of a man who really was wrongfully charged and arrested. So thankfully, the system worked and charges were withdrawn. But yes, I think there will be people out there who will say, he got away with something, or, slimy defense lawyer who did something to get this guy off, and so on and so forth. And again, don't be distracted. It's quite the distraction when people say those types of things. That's not our focus, and nor is it our role in this process. So, I tend to focus on my client and their families more than I do public perception of what I do.
Now, sometimes though, I guess it may involve, like, the media asking for a comment on a case, or sometimes you may need to make a statement in the media.
Mhm.
Now, how do you kind of advise young lawyers, young legal professionals, of finding that balance of, is it just sometimes just a no comment and continue on, like you were just saying about trying to get rid of any distractions, or where it may be in the client's best interest if there's some information discussed there? How do you kind of figure out what works best in a situation like that?
I find lawyers sometimes get caught in the beginning of a case being asked to comment on a case, and I know our knee-jerk reaction is to be vocal, right? That's what we do. We speak. We like to hear ourselves talk. That's why we're defense lawyers. And in my view of things is that when the case is just starting and we know very little about it, it's best to really be quiet, right? So it's best not to litigate a case in the media, and it's best to be quiet. The time to talk is when things are over and done with, and you have an opportunity to be better situated, better to understand the entirety of the case rather than an off the cuff comment. Those off the cuff comments tend to get us into trouble. And so I think, we should all benefit from a practice for ourselves, which is don't be so eager and quick to speak to the media initially. I would say wait until you know more about the case and can more intelligently discuss a case. And that usually comes far, far later in the process. So um, my advice is don't say anything until the case is over and you have an opportunity to digest what happened.
Perfect. Thanks for that. And another kind of related sort of question there with media and coverage and perception there is, when you're starting off as well, um, what are some of the challenges? Now, we talked about obviously the challenges of starting a practice, but in terms of just sort of getting your feet wet, you mentioned it's a very steep learning curve. What are some of the kind of common mistakes you see that young lawyers are making on matters there, whether it's at the trial itself, or it's maybe in reviewing some of the disclosure beforehand and capturing something that may have been missed? What advice maybe you can have with someone getting one of their first few files about, on top of obviously going and seeking out experienced counsel,
Mm-hmm.
what are some things to kind of really focus in on that you may not be very familiar with when you're initially starting?
So, I mean, I have a couple students that are working with me now, and I also have a couple of young associates. And I can say across the board, I find organization and preparation is probably the number one thing that we ought to focus on. Which, again, I don't think is something that's taught in law school. Is how do you organize a file? So you've been given disclosure. Forget strategizing. We're not even there yet. I'm just talking about simple organization skills rather than showing up to court and pulling out the disclosure from, the DVD or the USB stick. I'm saying, how do you organize a file before you even begin thinking about it? And my view of things is you really have to take a moment to download everything, put it in an order that works for you. I mean, I use an index and I tab everything, including officers. We arrange them, we color code things. So, CFS is covered one way. So any forensic type evidence is color coded. Officers are color coded. Civilian witnesses are color coded. And then you've organized your file, and then you have an opportunity to sit down and really digest it. Then you move to the next stage where you begin to strategize your case. And I find a lot of lawyers are jumping into wanting to litigate, and you're going to get there. You're going to get your day in court. You're going to get your day to cross-examine. But if you're not prepared and you're not organized, then it really doesn't matter if you're litigating in court, right? And so I always say you need to have the directions before you start driving. And the directions really are our preparation and our organization, which people don't see, right? They don't see what goes into a file. So when the client says, I paid you this much money, what'd you do for me? The truth is you don't see it. You don't see what we're doing back in the office. You don't see the work that goes into, reading every word in an officer's notebook, every word, not glossing over it. Every word needs to be read. It needs to be compared to the other officers. It needs to be compared to the civilian witnesses. A warrant needs to be picked out line by line by line. I mean, all of that takes place behind the scenes before you even walk into the courtroom. And I find with a lot of young lawyers, there's a lot of steps that are missing before they enter the courtroom, and it really detracts from their ability to be great advocates, because in order to be a great advocate, you need to be organized and you need to be prepared. So I would say that's the number one hiccup that I see. The second hiccup I see is writing. I I find the writing is atrocious. I don't know if it was just different in my time where we would submit something to a law professor and it would come back with like, are you an idiot, like crossed out in red, like what are you thinking? Maybe like law professors aren't being harsh enough these days, I don't know, but I find the writing to not be great right now, and that's being brutally honest. So I find like factum writing is really important, right? Because it's an impression that you make with the judge when you file that charter application. They get this great factum that's well organized and well thought through, and a judge will say, okay, I mean, like this is going to be a hell of an argument. But if it's like slapped together because you think that you're going to leave it all on the floor when you come to the courtroom, I think it's a mistake. I think it's a misconception for lawyers to think that they can argue their way out of a shitty application. You can't. You need a great application, a great factum, and I think it speaks to how organized you are, right? I mean, it's a package. All of it is a package. How you think, how you organized, how you speak, how you move in court, all of those things are they're learned. And again, you can hone those skills, but you need to have them. And so rather than just showing up to court eager to, cross-examine the hell out of the police officer, think about, am I prepared? Am I prepared? Am I organized? Do I know what I'm doing? Am I asking questions I already know the answers to? Those are the things that I think sometimes are missing when young lawyers are too eager to get in there and advocate.
So what are some ways they can better prepare that and organize and develop their writing? And I think perhaps maybe sometimes it's we've had the forms, right? The form ones where mm-hmm. some people are using it, you have to be very succinct rather than where you would be able to, I mean, I guess some people will still see Schedule A and then throw it all out in there, but is it sort of, what can they do to be better written advocates there, as well as kind of be a bit more prepared? And is it something that just comes with experience, or is this again, seek out mentorship and run it by senior counsel first? And what's there?
Yeah, I mean, I think it's a little bit of both. I mean, I still get calls from other lawyers about, Leora, can you look at this warrant for me? I tend to have picked apart a lot of warrants in my career, and like 21 years that I've been at the bench. I've got a lot of lawyers, senior lawyers as well, who will say, listen, this is what I'm thinking about this warrant. What do you think? This is an argument that I'm kind of honing. Do you know anything about this? So again, I think you need to seek out some assistance. But as far as organization goes, I find in this business, everybody organizes a little bit different. And I only know that because sometimes we'll inherit a file from another lawyer, or another lawyer will inherit my file. And I tend to print everything. Younger lawyers, I find, love, the sort of the technological side of things. I don't, maybe because I'm not well versed at it, but the younger lawyers in the office are, and they don't need to print everything. But in my office, I make them print everything. I tend to think that you can miss a lot by skimming on your computer. For me, that's what happens with me. Maybe I'm old. So I need to print it all and feel the paper and use my highlighter. And I tend to feel like I don't miss a lot if I print it all. So it doesn't matter the size of the case. If it's a large project, I still print everything because I want to read everything. So I would say don't be afraid to print. If you're getting things in a DVD or a USB stick, please print it, read it, because I feel like you might miss something. As far as writing goes, though, I think it's just practice, really. I don't use the form ones. I know you have to fill them out. I fill them out in a generic kind of sense, and then I attach the regular notice of application and factum that I've been accustomed to for the last 20 some odd years. I like doing that. It sets out my argument. It helps me focus. And I find I rely on it when I'm in court. Well, I'll say to the judge, part of my argument is found at paragraph 16, and we turn to paragraph 16 together. And I also think it puts the Crown on notice as to what the argument is, so that both advocates can focus in on what the argument is. So I think it does get better. I mean, I tend to think that my writing has gotten better in over the last number of years, but I've had people look at things for me. What do you think? I'll still flip a factum to a dear friend of mine and say, hey, what do you think? So again, I think it's one of those situations where you can't be embarrassed or ashamed to ask someone to read it over, and see if you're on the right track. The young lawyers in the office, I make them take a stab at an application, and it'll go back and forth a number of times, before they feel that they've gotten it right. And I think if you ask them, they'll tell you that they feel that they've gotten better over time, being more succinct and more precise in what that argument is. I think that it's just time. It comes with time, like anything. You get better as more and more you do them.
Great. And I do have some students that are doing like a little mock trial next week. And their first kind of, I think, real experience of doing something like that. So I think they're very, very nervous there about going through it. So maybe you can share some pointers there. Let's maybe start from different aspects of the trial there. Let's go with like an opening statement, right? So they're kind of like, what do I put in my statement? What do I need to explain? What do I need to cover? And I know obviously for paralegals that are listening that, you won't have jury trials, but just, well, in some tribunals, perhaps, they may give you an opportunity to give an opening statement, but maybe you can share from your latest one there that what are some things that you want to highlight, and what are some hallmarks of a great opening statement?
So it's funny, in 20 years and all the jury trials I've done, I've never done an opening. I'm always asked, of course, we're always asked, do you want to give one? And I never do. And I guess it's because I never want to give away what it is I'm about to do in court. And so I tend to love the fact that I'm a defense lawyer and don't have to give an opening to sort of foreshadow what I'm doing. And maybe it's because I like to change my mind if I want to during the course of a trial, right? I mean, in the last murder trial I did, it started off being an ID case and turned into a self-defense case. Like, I want to be able to evolve and change my mind if I want to. So I don't want to be necessarily pigeonholed into a particular argument. And maybe that's why I don't do an opening. I don't know. So I guess the best answer I can give you is I'm not the right person to ask about an opening. Closings, I can tell you, when I close to a jury, and people will laugh at this, I think every closing I've ever done in 21 years, I've run by my husband. Every single one of them. This poor guy has had to sit on the couch and listen to every closing argument. He knows nothing about the case. Knows nothing about the evidence, but he listens to every closing. And listen, I don't think he's ever said, "Hey, that was a terrible closing." But I think it's an opportunity to be able to be in order at home in your own comfortable surroundings before you actually, convey it to anyone, including a jury. As far as closing to a judge, I tend to write things out. I know my staff doesn't think I do that, but I do. I don't write out my cross-examination questions anymore. I used to when I was a young lawyer, so that I never missed anything. But as far as closings go, I do. I write them out. I try to ensure that I don't miss anything. I never really talk off the cuff. I like to be organized in my thoughts and to be articulate. And I find that I have to write things out. Again, I don't think there's anything wrong with that. And good judges, I find, will often, interrupt and want to engage with you and ask you questions. So you have to be able to move off your script, so to speak, and then come back to it. But I like having the security of having my closing there. And so if young lawyers are thinking, is it okay if I write things out? The answer is yes. That's your comfortability and your ability to be controlled in how you lay out your argument. So I say, don't be afraid to write things out, and to practice them on people and family members. There's nothing wrong. There's nothing wrong with that. I say do that.
It was just great. Now I'm going to have students like, oh, I'm just not going to do the opening now because Leora
Sorry.
doesn't. But it's probably one of the
Sorry.
things that there are other things that we can maybe move on to questioning is like never ask a cross examination a question you're
Never.
not going to know the answer for. So I just did that on purpose there, everyone. It was I knew she was going to say that.
Yeah.
What tips there for direct and cross examination, especially that
Yeah.
I think even 20 years later, you could listen to like another Posner and Dodd sort of seminar. You're like, oh, I never thought of that, right? So
Absolutely.
what can you
Absolutely.
share?
And the truth is, John Rosen and I are very close. And whenever he was in a courthouse and I happened to be in the same courthouse, I would say to him, John, do you have any cross examinations going on today? And this was even as late as, I don't know, 2 years ago. I would say, John, are you crossing anyone today? And he would say, yeah, I have, someone in the stand. And I would go and I would watch. The late Eddie Greenspan, I saw, one of his last cross examinations. I happened to be at 361 University. He was there. I went in and I watched. I find, like, again, every lawyer has their own creative style, right, as to how they cross examine. And, you learn from other lawyers as well. I think a part of being a good cross examiner is innate. It comes with who you are as a person, and that necessarily can't be changed. But I think you can hone those skills, and you do that by learning and watching other lawyers. So if there's ever a moment in time where you have the ability to watch another lawyer cross examine, go watch, see how their mind is working, and see what questions they're asking. As I said in the beginning, I would always write down my questions. Not so much the actual words themselves, but at least the umbrella, I would say, of the area that I wanted to cross-examine on, right? So if it was like someone's intoxication, I would list all the questions that I wanted to tick off under that umbrella, and I'd move to the next umbrella. Now, not so much. I find like I usually know where I'm going in my head, and I get a feel for a witness and I can move them around. I also don't like to do things chronologically. Other lawyers will tell you they do. They like to go in a chronological order. I don't. I tend to be one of those lawyers that moves you from A to F, from F to Z to, I like to do that. I think it moves the witness around. And when they think they know where you're going, they don't really know where you're going. So I prefer to work that way and to sort of change it up and not do things chronologically. Um, Aside from that, as I said, I would write everything down, be organized, but cardinal rule, you never ever ask a question that you don't know the answer to. So open-ended questions in examination in chief are fine, but even then I know the answer to it. So if your client is testifying, you better damn well know what he or she is about to say. And there is that odd time where they say something and it hasn't necessarily been run by you and you're shocked by it. But ordinarily, you pretty well know what he or she should be saying, including witnesses. And that goes back to the preparation and the organization. Cross-examination is, as I said, it's an art. You know that. I mean, it's a skill that you learn, and it gradually does get better and easier. There's a lot of nerves, I think, in the beginning because you want to make sure you're doing it right and you haven't missed anything. I would say also slow down and take your time. I find young lawyers are quick to get their questions out and then quick to sit down. And I would say at the end of your cross-examination, stop, stand at the podium for a little while longer and think about everything you just heard. And if something else comes to you, then you have that opportunity to ask the question. I find also, if you have a script, that there's a tendency sometimes to look at that script and not engage with the witness. So if you are going to write things down, make sure you look up and feel your witness and see them and assess their demeanor, because you may have a follow-up question that isn't on your script. And so sometimes you can miss that if you're too wedded to the script. So be engaged with your witness, feel your witness, and take your time, even if it's forced and you have to take an extra breath or two or a pause in between the questions. Don't be in a rush. And I think that'll help to hone your skills. Those are just some of the things that I do daily.
Yeah, and I think I would echo sort of that. If you have a script, then don't kind of use it as just a crutch there, because you may
Mm-hmm.
have a great answer that's really helpful, and you've completely tuned it out because you're like, "Well, what's my next question here?"
Of
But what
course.
about if it indirect there? If you do have the client that kind of goes and veers off in a little direction, like what can you do to kind of, other than have your jaw drop and like, oh no, what do I do? And then everyone can see that look on in your eyes there. What can you do to kind of recover from that and move on?
The answer is not much. It happens too. I mean, I've had clients testify in very serious charges, and you've been through the narrative, 100 times, every which way to sundown, and you've done mock cross examinations, and you've had associates cross examine them, and you think you know everything, that you've done this 100 times in your mind, that nothing could possibly go wrong, and then they take the stand, and it's like, what? I never heard that answer before. And so I think you just, at that point, rather than take your pause, quickly move to the next question, right? And get them back on track as quickly as possible. I think you know it as a lawyer when something has gone awry. And I think the truth is you got to keep your poker face, right? And to not let someone know that shouldn't have been there. Good Crown attorneys, of course, will, I'm sure, pick up on it, but I think you have to pretend like you didn't just hear that and carry on with the narrative. You'll have to deal with it in another way, maybe in submissions, maybe in a reacts, maybe in a different way, but I think you have to keep moving. It can't be a long pause like, oh no, that shouldn't have come out. It's got to be, okay, next question. And you move along. So I think part of us being defense lawyers, I mean, the late Edward Sapiano used to say we're all failed actors, right? Which is what I think defense lawyers really are, is that we love to act, we love to perform. And part of your job, I think, at that stage is to be a great performer.
Now, speaking of clients, another thing that, and I always try to get a little ethical content here, is maybe one day get it accredited. But what do you do with just maintaining sort of the expectations of clients and balancing, the clients who want, especially when they're facing such serious charges, right?
Mm-hmm.
That there could be a
Mm-hmm.
tendency of, calling you up and saying, hey, what's going on, or what happened at my crown pretrial, and what's going on with the judicial pretrial, or why is it not being scheduled? How do you kind of temper sort of, client expectations, as well as obviously ensuring that there is enough communication, especially when you have so many files and things going on? What sort of strategies do you have for young lawyers who may not know how much to take on, and how to kind of maintain that balance between sort of the very needy client versus being too distant, and they're left like dissatisfied and wanting to go somewhere else?
Yeah, I mean, it's a hard balance, I think. But I think, in fairness to all of our clients, they really are probably at their worst, right? People charged with offenses are really going through a horrible time in their life, and I think sometimes we forget that, and we carry on like this is a business. But the truth is, it is someone's life, and there are, I'm sure, additional pressures, associated with being charged. So I think sometimes we forget about that because we're so focused on representing them that we forget the real humanity behind all of this, which is, I'm being charged with an offense. I'm looking at jail time. I've got a family. I've got loved ones that are counting on me, and they're stressed. And there's a lot of anxiety that goes along with this process. And I always say to people, the punishment really is in the process, because it's lengthy, and it's long and arduous. And, I think you just have to be really patient. And again, I think that comes with time. And as you get older and more mature, you learn to obviously balance that a little better. There are those clients that are just really needy. And those are the clients that sometimes you need to have a heart to heart with, to say, listen, I understand your stress and I understand the pressure, but I'm doing my best, and I'm happy to advise you as to what's going on after every court appearance. But sometimes some court appearances are just administrative and there's not much going on. But believe me, when something major is about to happen or has happened, you'll be the first to know. So I think at some point you got to reel in the clients that are really, really needy. there are other clients that you just recognize need handholding. We represent people, who are quite disadvantaged, sometimes come with mental health issues. And I think you got to be sensitive and alive to those issues where you are going to be the social worker likely for the next 18 to 30 months. And you are going to have to hold this person's hand, and you are going to potentially have to deal with their family and their parents. And that's just what we do for a living. I mean, it's hard and it's difficult, I'm sure, on all of us. But again, I think we need to recognize the people that we're representing, right? We're not doing mergers and acquisitions, and we're not tax lawyers, right? We're people taking care of very vulnerable, oftentimes disadvantaged people. And I think the quicker we recognize that, I think the easier life might be for us, where we can actually take a step back and say, okay, I understand why this person's calling me all the time. So don't be afraid to reel them in a sensitive way, in a diplomatic way, where you really, you're sensitive and alive to some of the concerns that they have, but you're also wanting them to know, hey, I also need a little bit of my own time. I have my own family. I'm happy to address any concerns that you have, but you can't call me every hour on the hour. So reel those clients in when it's time to do so. Recognize the ones that need a little bit more affection from us, but be alive to who we represent and why we do this job. It's a tough job, but we do it.
Yeah, certainly. And you've been doing it for the last 2 decades here. And then
Yeah.
anything there over those 20 years, I mean, if you could do anything differently, or, really happy with the success that you've had over the 2 years, I mean, sorry, 20 years or 2 decades, anything, I mean, if you look back and say, I should have done this, now you have the benefit, hindsight 2020 always, or is everything the same there for you?
You know what? I've been really fortunate. I say that all the time. Like, I've had such a beautiful career. I had hiccups with my own legal challenges that people ask me, would you have done anything different? And the answer is a resounding no, I wouldn't have. It was unfortunate what happened to me. But having said that, I still really love the judicial system here in this country. I think there's room for growth in our system. I think mistakes happen, and I think there are dangers and pitfalls associated with some of those mistakes. But overall, I've been really blessed with a beautiful career. I don't really regret anything. I've had great mentorship and great articles, great people that I call on and rely on, wonderful colleagues. Yeah, no, I don't think I would change a thing. I really think that I've gotten what I wanted out of this profession.
Yeah, and it's great to see that you haven't changed that approach even after going through all of that. That you're still
Mm-hmm.
there being tough on the officers and still raising those points where needed. So, thanks so much again for taking the time here and joining us. Just wondering maybe if you have any final words of wisdom now looking back, what you can share for those who are about to embark in their career or just starting their career. There's a lot of challenges, a lot of difficulties, especially in criminal defense. And we were talking about, some people will, have a little bit of that noise there, like, this skeezy criminal defense lawyer, and kind of having to deal with that and putting that away. But what would you share then for anyone looking to get into this profession, and how to overcome some of the challenges, and in particular, young lawyers or especially women getting into a profession that's traditionally been, very male, how to kind of
Yeah.
overcome a lot of those obstacles?
Yeah, I mean, listen, I found in the last kind of 5 or 6 years that young lawyers are rushing to hang a shingle and to become, self-employed and working on their own. And I often shake my head at how quickly young lawyers are wanting to be on their own without any real mentorship. It wasn't like that when I started criminal law. We often stayed at firms for, a lengthy period of time until we felt comfortable, and then we went on our own. I mean, I find in this business, no one ever stays anywhere for forever. That everybody, traditionally wants to do things on their own and wants to be their own boss. And I certainly encourage that. But I find that young lawyers nowadays are really anxious to be on their own, and that they're lacking the mentorship, which means they then have to make these cold calls to lawyers that they don't know, and they don't necessarily have a connection to. And so I would say this: I certainly encourage young lawyers to be independent and to forge ahead with their careers. But I would say do it slowly. Don't rush. You have so much time in this profession for growth and development. And I find that the infancy stages of becoming a lawyer are so important for the length of your career. And so what I would say to young lawyers is, don't rush. There's so much time to be on your own and to be your own boss, that I think that people ought to spend, some time developing and honing their skills under someone else's umbrella, so that they can make the necessary connections they need to network well, so that they have people in place that they can call on. And I think they're missing that when they're running out to hang a shingle saying, I can do this all on my own. I think they can. Many people can. I'm just saying, it might be easier to have some mentorship. And if you can get that mentorship before you rush out and do it on your own, it might be a little bit easier. Otherwise, as I said, it's a thankless job more often than not. We don't really, you're with a client for, 2, sometimes 3 years, and you feel like they're part of your family, and then they're gone. And more often than not, you don't see them again. And so it really is a thankless job, and you devote really your blood, sweat, and tears to this job. I always say to people, some days it feels like so soul crushing, but there are so many rewards, and although you don't think you're getting them, you are. So as I say, it's a profession that's so complicated, but so rewarding in so many respects, and so many other respects that people don't necessarily see. So listen, I encourage people to go into criminal law. I think it's an amazing job, where you really do get to advocate and be an orator for people who really don't have a voice in the system. So it really is a profound and amazing profession. It just takes time and patience, and an incredible amount of tenacity. So with that, I want to encourage young lawyers to reach out to me and to others who are willing to help and to guide. I'm certainly here to do that, and I would be happy to.
Perfect. So thanks so much once again there for joining us today, sharing
Thanks,
all
John.
sorts of insight there. It's always great to hear from people who have been practicing and very successfully practicing. And again, it's hopefully people can take that and say, look, I listen to Leora. She's very approachable. I'm going to go and reach out to her and ask those questions, right? And if if that helps kind of reach out to other counsel as well. I think as you echo that, right? It's that you're not going to know until you have that experience, and go to the people who have the experience and ask them those questions. And they're not going to. I mean, the worst, like you said, is they're going to say no, and you can ask somebody else. And
Absolutely.
I mean, 99% are going to say yes there anyways.
Even judges, right? So if you're getting ready for a trial, and who your trial judge is, but you know the name of the trial judge, but you don't know what they're like, short of just obviously researching quick law and Canley, you may want the skinny on who the judge is. And so you want to call up a colleague or someone else, another lawyer, and say, hey, have you ever done anything in front of this judge? I still do that. I still have colleagues who call me. What do you think of this judge? What do you think of that judge? What do you think of this crown? I mean, you want to know where you're going and who you're appearing in front of, right? That's really also very important. Part of your preparation and organization is knowing who your judge is, who you're being received by. And you want to know how to necessarily convince this judge, and what do they like and what don't they like, and are they curt and are they pleasant? I mean, you want to know those things before you walk into the courtroom. So as I say, plan ahead and use lawyers to assist you in planning ahead. There's so many of us that are approachable, definitely.
Sounds great again. So thanks again. And thanks everyone
You're
for
welcome.
tuning in, and all the best. Continue. And I love hearing those great stories, and people share them from the last few weeks there, especially. And all the best. And I guess you're going to have your wish, maybe have a lot more in-person things on your plate as well. So take care.
Thanks so much, Jumbo.
Bye, everyone.
Take care. Bye-bye.
Thanks so much, Leora.
Oh, thanks for having me.